All right. Hi, everybody. Thank you for joining us. And I thank you for everyone who, I don't know if anybody was signed up to appear in person, but thank you for letting us switch over here to Zoom. It's very unpredictable times right now, but at any rate, so my name is Alyssa Chow. I'm an attorney here in the Sacramento area, and I primarily practice in the area of trust and estates. So for today, we're really just going to be going over what you can expect if you're nominated as a trustee, executor, or an agent. So we'll kind of go through what the documents are that any of those would pertain to. And then at the end, we can open it up for questions. I just kind of want to give people some general ideas of what they can expect. And yeah, so we'll just go ahead and get into it. So let's see, I think I can share with everyone. Okay. And if anyone can't hear me or if they can't see anything, please let me know. So first, what we want to talk about is just breaking down the various roles that you would potentially be acting as either trustee, executor, or an agent. It all depends on what document you've been nominated in any of those capacities. So for a trustee, the terminology would apply for a living trust. If you're an executor, that's going to apply to a last will and testament. And then if you're an agent, that's going to apply if you are appointed under a durable power of attorney and or an Advance Health Care Directive. So we'll talk a little bit, if you haven't seen any of my previous presentations about sort of estate planning 101, we'll talk a little bit about what it means. Ooh, there's a little bug in front of me. We'll talk about what it means for each of those different documents. So just to start it off, with a living trust, this is a legal contract that essentially provides the instructions for control, management, and distribution of assets. And really, it serves as a legal key to you as the trustee and would provide you with access to assets that are funded into the living trust. And we'll talk a little bit more about what funding of a trust means, because that will have a big impact on your duties and responsibilities if you are acting as someone's trustee. Generally speaking, when we're dealing with a living trust, we're hoping that that can be managed outside of the context of a probate court. And we'll talk a little bit about the probate court as well. But, I do practice also in the probate court context. And I will say that when you're dealing with the probate court system, it's really slow. So hopefully the goal with a living trust is that that can be administered much quicker and that you as the trustee have a little bit more flexibility and less court oversight in managing a trust affair. All right, and then if you're acting as an executor of a last will and testament, a last will and testament kind of falls within one of two categories. So the first one is going to be a standalone last will and testament. And that's typically going to be a situation where the person who created the will, we typically refer to them as the testator, they would specify who the beneficiaries are and who the executor is who will administer the will and kind of manage the assets of their estate. Now, when I say standalone, this typically means that this person created their will, but did not create a living trust as well. Now, on the other hand, there is what's called a pour-over last will and testament. And this type of document is created in the context of a living trust. And really, when you're creating a pour-over last will and testament, it really just serves as a backup document to the trust for any assets that were not properly funded into the trust. So really what that means, and the reason why we call it a pour-over, is that in case someone were to pass away and they left assets just in their name individually, there was no joint ownership, the property wasn't titled in the name of the trust, or there was no beneficiary designated, then a pour-over will would basically serve to scoop that asset up and pour it over into the trust. So we really just want to make sure that assets are redirected back to the trust as much as possible so that all of the instructions that the person painstakingly put together are actually followed. Okay. And then the other document is a durable power of attorney. Now, this would be if you're acting as an agent. So this type of document allows someone who we typically refer to as the principal to appoint someone else who we would refer to as their agent, which in this context and in the context of this presentation would be any of you who are, watching this presentation. And that gives you the ability to act on behalf of the principal regarding their finances and their other personal affairs. Now, this typically would occur either immediately if the principal gave you the immediate authorities to start transacting on their behalf, or it can be what's known as a springing power of attorney. And that would only become effective upon either one or two physicians diagnosing the person as being incapable of managing their own finances before you as the agent could step in. So it's really important that when you're looking at a durable power of attorney, if you've been appointed, to see what that triggering language is as far as when your authority becomes effective. Each power of attorney is going to be drafted slightly differently depending on the preference of the principal and what steps they wanted you to follow before you can step in and assist them with their financial or other personal affairs. And then the other document is the Advance Health Care Directive. And I think people are probably pretty familiar with this document because anytime you go in to the doctor's office, they typically will ask, do you have a healthcare directive? And if the principal, the person who creates the document, does have one, then they would provide it to their healthcare provider. And that healthcare provider would then know that the person who they've appointed, in this case, potentially you as the agent, that you have the authority and ability to make medical decisions for the principal and be able to respond to and coordinate with any sort of healthcare providers. Now, similar with the durable power of attorney for finances, the authority to step in and make any medical decisions or correspond with the principal's healthcare providers is going to depend on whether or not the principal created an immediate or a springing power for you as the agent. And you won't really know unless you get a chance to see the healthcare directive. So it's really important to check there and see, what the principal put in place as far as the triggering language for you. All right, so we've talked about this a little bit, but the next question that we always get to is, all right, so if you're acting in the capacity or you're expecting to act in the capacity of a trustee, an executor, or an agent, when does that actually, when does that actually come into effect? So first with a trustee, kind of similar to what we've been talking about, but there's three real primary scenarios where you would be able to step in as a successor trustee. Typically, that's going to be either upon the incapacity of the previous trustee, which could either be, the person who created the documents, which we would refer to as the trustor, the settlor, or the grantor. Now, if they become incapacitated and you're the primary successor trustee, then depending on the language in the trust, that may either require one or two physician signatures or maybe some other requirements that were drafted in by the trustor. But upon their incapacity, you would be able to step in. Now, it's also possible that somebody else was a trustee nominated before you, and if they become incapacitated, then you may need to step into their place as well if you're the secondary nominated trustee. Another situation where you may step in as a trustee is if the previous trustee, whether it's the trustor or just another trustee, whether they have just resigned, right? It's not uncommon that I have clients who come to me because their parent is maybe a little bit older and just they don't want to manage things for themselves anymore. And so their parent decides to resign as a current trustee, and then therefore that would trigger their child to step in. In this case, if you were the named successor trustee, if your parent or whoever it was who created the trust decided to resign, then you could step in and actively start managing things for them during their lifetime. And then, of course, the death of the prior trustee would also be another triggering event in order for you to be able to step in if you are the primary successor trustee. Ooh, sorry about that. And then as far as an executor goes, if you're going to be the executor of someone's will, then that would only occur upon the death of the person who created the will. So we refer to that person as the testator, the one who did create the will. Now, it's the thing about if somebody had just a standalone will, then, or even with a pour over will, I guess in any event, those documents, because they don't become effective until that person passes away, you would never be an executor while that person is still alive. So you may be nominated, but you're not formally acting in that capacity until that person passes away. And you may not even be formally appointed to act as an executor unless a probate administration is necessary. So we'll talk a little bit about that in a little bit. And we already went into, for an agent under either a durable power of attorney for finances or an Advance Health Care Directive, regarding whether you can act immediately upon execution of the documents by the principal or only upon their incapacity. Okay, so what next? I'm going to talk more in the context of if the person who created the trust passed away. So for this slide purpose, we're really just talking about if someone created a trust, they died, and then you were named as the primary successor trustee, then generally you have a few basic steps that you have to follow, but they're very important, very critical steps that you want to make sure that you get right. So the first step is always going to be to actually review the trust. I can't tell you how many times I meet with people and they bring me the trust and they've never looked at the documents, which is okay. It's quite a few documents that you'd have to be looking through, and it's all in legalese. But what is not uncommon is that people will come to me, bring me the trust, and then proceed to tell me that they've taken a bunch of actions that are not actually allowed in the trust or written down in the trust, but are things that, they thought that maybe was actions that they took in the name of fairness or based on a passing conversation that they had with the person who created the trust. So it's really important that you make sure that you're following and taking action exactly as it's stated in the trust. You can't really go rogue as the trustee and, for example, start giving out a bunch of gifts from the trust because that's what you think that the trustor would have wanted. Unless it's specifically listed out in the trust, you really can't take any action outside of the four corners of the document of the trust itself. There are always some exceptions to that, but for the most part, you want to make sure that you're following the very strict instructions that are provided in the trust. And then the next step that you really want to do once you've identified who all the beneficiaries are in the trust and who any of the potential heirs are, you want to do what's called a notification by trustee. So that's on this in this very specific format according to the probate code. It's probate code 16061.7. And under that probate code section, you have to provide certain information to all of the parties entitled to that notice. And that would be things like, your contact information as the trustee, that you've accepted the position as trustee, and just providing some basic information about the name of the trust and where the trust is going to be administered. So typically wherever you reside is going to be the county where the trust is going to be administered. A next really important step would be to consult with a tax advisor. Taxes are not the most fun sort of step that you would think that you need to be dealing with, but in the context of a trust, there are some primary things that you're going to want to be aware of. And again, this isn't if the person who created the trust has passed away, right? So we're dealing with a post-death administration. You're going to need to get a tax ID for the trust. You can't use the deceased person's social security number any longer. That really shouldn't be transacted on anymore now that they've passed. And then you also don't want to use your own social security number for any of the assets that you, what we call marshal on behalf of the trust. So it's really important that you do obtain a separate tax ID number for the trust. And that ID is going to be connected to any of the assets that you're managing on behalf of the trust. You're also going to want to file the deceased person's final income tax return for the year that they were living. So you're going to want to talk to a CPA or a tax advisor about getting that filed timely. And then you also need to evaluate whether any estate taxes are due based on whatever the estate tax exemption amount is at the time. The next step that you want to do is really inventory and what we call marshal all the assets of the trust. So whenever we're looking to see what items there are that you need to be managing as the trustee, we need to see what's actually been funded into the trust. And so an example of that would be, we really kind of look at it from 3 different perspectives. So the first would be assets that were properly funded and that are currently titled in the name of the trust. And you'd be able to see that from, if it's bank accounts, you can see it on the bank statements. If it's real estate, then you can see it on the grant deed. And then if it's like an investment account, you can probably also see it on the statements there as well. There's a second category though, which would be assets where the trust was designated as a beneficiary rather than where assets were actually titled in the name of the trust. Some types of assets that would apply to would be things like life insurance policies or retirement accounts, annuities, things like that. So as the trustee, you would need to reach out to all of the different financial institutions where the deceased person had accounts, or where that they had assets. And typically you'd have to provide an original death certificate to show that that person has passed away, and then to try to obtain as much information as you can about whether beneficiaries were designated or not. And then the third category of assets that you would be inventorying or potentially marshaling would be assets that were just in the deceased person's name, that didn't have a beneficiary, that they didn't own jointly with someone else, and that was not titled in the name of the trust. Now, depending on the total value of these assets, you can use that pour over last will and testament that we talked about earlier in order to scoop those assets up and pour them over into the trust. But it all depends on what the total value of those assets are and what types of assets they are. So if somebody left a whole piece of property, like a home or a rental property outside of their trust and they passed away, then it's possible that you'll still have to deal with the probate court system in order to get that property into the trust. But ultimately that property will follow the instructions of the trust. So that's also really important. Okay. So it's really critical that you are very careful about identifying which of these assets fall into, or I guess whether assets fall into any of those 3 categories, and that you don't take any action to fill out any sort of paperwork until you know for sure what all the assets are and which of those categories they fall into, because you may or may not require probate court action. And then finally, under the trust, you're also going to want to identify any debts that the deceased person had. Now that's probably things like credit cards or ongoing, if they have like a Netflix account or any other subscriptions. It's really important to be able to identify if there's any regular bills that are coming in that you either need to cancel or that you need to pay off on behalf of the trust. And so sometimes with clients, what they'll do in order to make sure that they're gathering up all of that information appropriately is either to get access to the deceased person's email account, if you have that access, if you're able to get their computer or log on, or if they've provided any of that login information to you, then you can get that information that way. Otherwise, you can also do a change of address form through USPS in order to get the deceased person's mail rerouted to you so that you can start collecting all of those bills as they accumulate. Okay. So that's really the main steps regarding a trust. Those are I guess I should say the primary steps. And then of course, depending on who the beneficiaries are, there's going to be a number of other steps that you're going to have to follow as well regarding distribution to those beneficiaries, and making sure that nobody is contesting the trust. One thing that I forgot to mention regarding the notification by trustee is that the moment that you send that notice out to all of the people entitled to that notice, that starts the clock on a 120-day contest period in which any of those interested parties could try to initiate a contest of the trust instructions. And so typically it's also really important that you don't do big distributions during that 20-day time frame, just because you don't want to distribute everything in the trust. And then on the 119th day, you find out that somebody has objections or wants to file a lawsuit for a greater share of the trust, but you can't defend yourself because you have no cash to defend yourself because you've already distributed all of the cash out. So it also is probably important that you talk to an attorney, at least at the outset of stepping in as a trustee for a post-death administration. That way you can kind of come up with a really good timeline and time frame for how to deal with all of the expectations and requirements of you as the trustee. All right. And then as far as if you have to act as the executor, it really depends on whether there was or was not a trust created by the deceased person. So if there was a trust, the first thing you're going to want to do is determine whether or not a probate is necessary. So like I mentioned before, you know, depending on the types of assets and the value of those assets, if they were left outside of the name of the trust or just in the name of the beneficiary, I'm sorry, the name of the deceased person, then you may have to deal with the probate court in order to get that asset sort of poured over into the trust. And you would have to be formally appointed as the executor in order to do that. However, if there is no probate that's necessary, then California has a funny little rule, and I'm not sure if there's the same rule in other states, but you would have to what we call lodge the original will. And what you're doing there is you actually have to provide the original last will and testament. And typically you want to bring in 2 copies with you. You'd have to bring that to the county court where the deceased person resided. And you give them that original will, an original death certificate, and then typically a $50 fee, unless the court were to change its fee schedule in the future. But the current fee is $50. And you would provide that to the clerk, and they'll take the original will, death certificate, and your fee, and they'll give you an endorsed stamped copy back that you can keep for your records. And they pretty much just hold on to that will forever. The sort of the idea behind that is that if a probate ever was necessary in the future, that the probate court will already have the original will on file so that it doesn't get lost right in the interim. And then in the other situation, if there was no trust, then the first step is that you want to do, kind of similar if you were the trustee, a post-death trustee, is you're going to want to review the will and see who all the beneficiaries are, who all the potential heirs at law are, because those could be different. And then you're really going to want to determine whether or not a probate is necessary. That's primarily going to depend on, again, the types of assets and the value of the assets. So you may want to speak with an attorney, or usually there's some free legal services that are available that can give you some general guidelines on what would constitute the types of assets or value necessary to initiate a probate administration. And then if so, then you want to get that started, because I will tell you that the probate court process is super, super slow. I would say on average, you're looking at probably a year to 2 years before any assets can be distributed to the beneficiaries or the heirs at law through a probate administration. And so if you can, I would recommend getting started on that sooner rather than later, just because you never know what could happen between now and then. So getting that authority to act as the executor is really important. That way there's no delay and potentially no assets that get lost. I have been presented with a couple of situations before where someone passed away, there was no trust, and either the person who died left a will or maybe didn't leave a will, and their family had to deal with the probate court process. It's not unusual that there would be like a primary residence. And if there's a mortgage on that primary residence, we want to make sure that we're sort of hustling to get somebody appointed as the executor as soon as possible so that that property doesn't go into foreclosure. And then there's a big loss to the estate. But sometimes there's not much we can do about it depending on how late in the process, the family is, and whether or not the property has been in arrears for a while. All right. So what next if you're acting as an agent under a durable power of attorney? Now, the powers of attorney are really only good during lifetime, or I should say during the lifetime of the principal, because if you're acting as an agent, you're only able to exercise authority or do things that the principal could have otherwise done during their lifetime. So once that principal passes away, then your authority to handle any of the following items sort of ceases to exist. However, let's say you are appointed as an agent either immediately or the triggering language has been satisfied and you've stepped in as the springing agent, or I should say the agent under the springing power. Then number one, you're going to want to review the power of attorney, see what authority you were given under that power of attorney, whether it's a standard statutory durable power of attorney or a more long form power of attorney. And you're going to really want to determine what the principal's needs are. So typically that would include things like paying their bills, filing their tax returns, maintaining any sort of insurance on their home, other personal property or vehicles, their health care if needed, and then also dealing with things like Social Security, Medicare, Medi-Cal, or any other public benefits that the principal may be entitled to. And since you will be managing finances on behalf of the principal, then you may also be responsible for paying and coordinating any sort of caregivers or arranging for rides and meal delivery for the principal. And each power of attorney is, for the most part, I would say that they're pretty standard across the board, but it is really important to look closely at a power of attorney just to make sure that you're not taking any action contrary to the powers that have been given to you as an agent. All right. And then what next if you're an agent under the Advance Health Care Directive? So number one, as I've been saying, you're going to want to review the Advance Health Care Directive and just make sure that you understand as best as possible what it is that the principal would have wanted. Now, hopefully at some point, the principal would have given you a heads up of the fact that they've designated you in this position. And I would say the same thing for any of the other positions that we've been talking about today. But particularly for the healthcare directive, I think it's really important that you've had a conversation with the principal about what their preferences are for treatment or withholding of treatment, what their end of life decisions are, whether they have a separate POLST form, that's the physician's orders for life-sustaining treatment form, and whether they have any other preferences that you should be aware of, because you as their agent have sort of that final authority to make any medical decisions for them if they can't make them for themselves. And similar to the financial power of attorney, you're going to want to determine what the principal's needs are. So this could include, coordinating with caregivers about what care is needed and providing them with any of the medication or I guess any other medical information that they may need. You may also need to accompany and coordinate medical appointments for the principal. Thankfully, as long as your authority has vested under the healthcare directive, you should be able to speak directly with the healthcare providers and do all of that coordination on behalf of the principal. And so it's just real important to make sure that the triggering language has been activated. Okay. You're probably also going to want to assist with the picking up and maintaining of medications. And this is, of course, going to vary depending on where the principal is residing. If they're living at home, you may need to coordinate, putting together their weekly pill box and make sure that the pills are, set up on their behalf, of course, with the oversight and instruction of any sort of medical personnel, but you may be responsible for doing that. If they live at a facility that provides med management, then you may not necessarily have to coordinate all of that. You may just have to provide the medications to the facility and then they would take it from there. And then ultimately, you're just going to be making any decisions regarding the care of the principal. If that principal is not able to say what they want, or they're nonverbal or have reached a point where they can't really clarify or dictate what their wishes are, then you have a lot of responsibility as the agent under the healthcare directive to make those decisions for their benefit. And overall, under either of the powers of attorney for finances or the Advance Health Care Directive, you're ultimately just acting in the best interest of the principal. All right. So kind of just to sum it all up, some general duties that you're going to want to be aware of. You're going to want to keep really good records, especially if you're stepping in during lifetime, and it could be possibly years that you are helping someone manage their affairs, whether it's from a financial or a medical perspective. It's really important that you keep good records. Maintain copies of statements. If you're, issuing checks, make sure that you know what those checks were written for, because it's possible that you may be required to perform an accounting of all of the transactions that you've been engaged in. You want to make sure that you also don't commingle any of your own personal assets with that of either a trust or an estate or of the principal. So it's really important that you keep everything separate and that you don't mix up any of your own assets with that of the person or the estate or the trust that you're assisting with. You're also going to want to avoid any conflicts of interest. An example of a conflict of interest would be, for example, if there was, let's say, a trust that had a house and it was, it's probably worth like $500,000, and you really want to purchase the house from the trust, but you're also the trustee, and possibly there's, 3 or 4 other beneficiaries under the trust. You really don't want to abuse your authority as the trustee and decide to just, for example, sell that house to yourself for $100,000 or $200,000, right? Because really, if you were to do that, then you would be doing it to the detriment of the other beneficiaries and engaging in a direct conflict of interest and abuse that authority. So you just have to make sure that you treat everyone fairly and that you don't put yourself in a position where you're unduly benefiting from your position as trustee, executor, or agent. And then I've kind of peppered this throughout, but you're probably going to want to consult with an attorney, at least at the very outset of any of those capacities that we've talked about, just because you want to make sure that you don't make a big mistake, like what I'm, an example that I mentioned earlier, where, you act as a trustee and then you decide, well, my mom told me before she passed that she wanted me to give $10,000 to this great niece or great nephew, but she didn't put it down in writing anywhere. You could potentially get in a lot of trouble for giving that gift, even if it was something that she may have told you. So, you want to make sure that you're following all of the exact responsibilities that you have, and that you have someone who is knowledgeable in the field that can guide you and at least let you know yes or no sort of what route that you need to be going down. And it's not self-serving, I promise. It's more so just because when you're stepping into this position or any of the positions, it's a really big job and you're taking on a lot of responsibility. And so you just want to make sure that you're protected or that you're not taking any action that would open yourself up to potential liability in the future. All right. And with that, that's pretty much everything related to my presentation for today. And if anyone has any questions, feel free to unmute yourself and I'd be happy to answer. Or if you want to, you can also send me a message in the chat. Okay. All right. Well, yeah, if nobody has any questions, then thank you so much for attending this presentation today. If you want to, feel free to reach out to me, and I'm happy to answer any general questions that you have if you are supposed to be acting as a trustee, executor, or agent. And then, yeah, just thank you so much, and I hope you all have a really good day.